Hello, my name is Melanie Gold. Welcome to the information session for the Access to Appellate Justice Pilot Program, or as we call it, ATAJ. And congratulations on being accepted into the program. You are part of a nationwide civil Gideon movement that seeks to provide access to justice for civil litigants not only in the trial court, but also in the appellate courts. San Diego has been on the leading edge of this movement, providing a monthly workshop to help educate self-represented litigants on the mechanics of bringing an appeal. But for those of you who have volunteered in that program, we have seen that gaps remain. Litigants still have trouble perfecting a record and making reasoned arguments. Without this ability, the appeals are often dismissed on procedural grounds at the early stages, creating both the appearance and the reality of not being served, of justice not being served. This pilot program seeks to address this problem by helping low-income, self-represented appellate litigants find an attorney who's willing to represent them on a pro bono basis. This concept has been supported at the highest levels in this court. As the California Supreme Court Chief Justice Kantil Sakue recently stated, we must ensure that income inequality doesn't translate into a two-tiered justice system. Your help in this program is a win-win on so many different levels. For the justices, approximately 1/3 of the cases in the Court of Appeal, 4th Appellate District, Division 1, have at least one self-represented party. And attorney assistance on these cases is invaluable. For the clerk's office, to reduce time spent with self-represented parties. For the litigants, regardless of the outcome, attorney representation will enhance a critical component of our justice system, which is providing litigants with procedural fairness, which builds confidence and trust in the courts. You will be hearing from 3 speakers today. First, Lisa Cannon, who is a law professor at the University of San Diego School of Law. Second, David Kay, who is a sole appellate practitioner who has represented non-institutional clients for going on 40 years now. Third, Kevin Green, a certified appellate specialist who has practiced in San Diego for 20 years. So Lisa will first go over the ATAJ program mechanics. David and Kevin will then walk you through a typical appeal, highlighting issues that would tend to arise when representing parties who were not represented in the courts below. Specifically, David will discuss issues pertaining to the attorney-client relationship, the notice of appeal, the civil case information statement, and the true filing requirements. Kevin will then discuss record designation, briefing, oral argument, and opinion and post-opinion matters. If you have questions about the program mechanics, you can email the program at sandiegoataj@gmail.com. And on substantive questions, remember, we have a fantastic mentor panel, and another excellent resource is the step-by-step appellate manual that you will find on the Court of Appeals website. We thank you so much for your participation in this program, and good luck.
Hi, I'm Lisa Cannon, and I'm going to be talking to you today about some of the mechanics of the ATAJ program. So first of all, to go over the qualifications for being in this program, to be an attorney who helps on the panel for this program, you have to have your own malpractice insurance. You have to have no record of any kind of disciplinary history with the bar. And additionally, you need to have had 3 years of experience plus 1 completed appeal in a California state or federal court, or 5 completed appeals in a California state or federal court. Lead attorneys may also work with other associates and younger attorneys who don't meet those qualifications, so long as the lead attorney maintains responsibility for the case. For the litigants in our program to qualify, first of all, we are only going to be accepting people for the program who were unrepresented in Superior Court and continue to be unrepresented, and the other side in the case was represented by counsel. This is how we're going to judge eligibility for now. It may be that in this case later on, the other side becomes pro se, but we're going to continue to consider this as a qualified case, as long as at the initial time we're screening the case, one side is represented and the other is not. We'll also be only accepting cases that are pending in the 4th Appellate District, Division 1. And finally, the case must be one where the applicant qualifies for a fee waiver. Now, at the time that we are screening these cases, most of the applicants will simply have filed their request for a fee waiver. The Court of Appeal may not have actually granted that fee waiver yet. And some of these applicants may have had a fee waiver in the Court of Appeal, or the Superior Court. However, they have to apply anew for the Court of Appeal. Having a fee waiver means that they don't have to pay for any filing fees or the cost of the clerk's transcript. We are going to leave it up to our counsel, once they take a case, to verify that the Court of Appeal has actually granted the fee waiver. Now, here's how our program works in terms of selecting cases. The process begins when a pro se applicant fills out our Google form. That information is put into a spreadsheet that our screeners will review. Once they determine that the case is qualified, then we will automatically move information over to a Google Sheet that all of our panel attorneys will have access to. These screeners will periodically email all of the panel attorneys to let them know that new cases are available. This Google Sheet's going to provide you with basic information that you can use to check for conflicts. It'll indicate the names of the parties in the case and some other basic information about the case, so you can determine whether or not you are interested in taking the case. To tell us that you're interested in taking the case, you'll add a comment to the Google spreadsheet to indicate your interest. And it's fine if several attorneys indicate that they are interested in taking the case. What we will end up doing is sending that information to the applicant, and then the applicant will be able to reach out to attorneys to speak about whether or not a relationship should be formed. So the applicants will contact the attorneys directly to negotiate that representation. David will be speaking more about how that representation will come to be. Finally, we ask that if you are successful in establishing a representation with one of our applicants, that you email the program back to let us know. Finally, I want to talk to you about the mentors who are available to assist you with your case. So once you've decided to take a case and establish the representation, the ATAJ program won't supervise you or continue to be involved in the case. It's going to be your case. However, we do have a group of mentor attorneys who've agreed to provide assistance to you in terms of advice. The mentors are going to provide us information that we will put into a Google spreadsheet that we'll share with you that will indicate the mentor's area of expertise and the kinds of assistance that they are willing to provide. And one important part of that is that the mentors, many of them, are going to be available to help you moot your case before it goes to oral argument. So interested attorneys will be able to add a comment on that Google spreadsheet to indicate that they are interested in the case. At that point, we will send you some basic case documents so you can further explore the representation. And if you are indeed interested in taking the case after that, we will then email the applicant directly with your contact information so that the applicant can reach out to you to determine whether or not you will form a representation. David will be providing more information later on about how you can establish that representation. Finally, we just ask that after you do establish a relationship with the applicant, that you email the program to let us know that that has taken place. Now finally, I want to talk to you a little bit about our mentors. So once you take a case, the ATAJ program won't continue to be involved. The program doesn't supervise the case. This is going to be your case. Mentors will be available, though, to provide you with advice as you go through your case. The mentors are going to provide information in a Google spreadsheet that you will have access to about the kinds of expertise they have and also the kind of assistance they are willing to give. One important kind of assistance that our mentors have already described a willingness to provide is to help you moot your case before it goes to oral argument. So that's all that I'm going to speak to you about today. Next, David is going to speak to you more about the steps of working with the applicant and establishing the relationship. Thanks.
My name is David Kay, and I would like to thank you for representing a poor litigant in the Court of Appeal. I'm going to give you the first steps that you need to follow when doing a Court of Appeal case. First, you're going to do a conflicts check. You're going to make sure that you have the ability to represent the client. Then you're going to review the notice of appeal, and you're going to review it for two things. Is it timely, and is it an appealable order? Now, it's going to be timely if it's filed within 60 days after the date of the order or the judgment that you're appealing from. If it's not, then you're going to have to look at the date of service of the notice of entry of judgment, and you're also going to have to look at the post-trial motions that are filed. If you're having trouble with that, I suggest you contact a mentor, and they can certainly help you with that. Is it an appealable order? Well, if it decides all of the issues with respect to your client and one other party, it's going to be an appealable order. If it doesn't, it may still be an appealable order, but you're going to have to look for specific code sections that allow for that. The next thing you're going to want to do is have a very realistic discussion with the client. The clients may think that they're going to get a retrial of their case in front of the Court of Appeal and that 3 justices are going to listen to the evidence. That's not going to be the case. They should also understand that legal issues are what are going to be presented. The timeline is also something they need to understand. It's going to take a year to process the appeal, and the results cannot be predicted. You're not going to want to tell the client that they're going to win or that they're going to lose. Look at the bottom line for the client. Do they understand that they may get a retrial of their case after the case is reversed on appeal, or do they think that they're going to win outright at the Court of Appeal? They're probably going to go back to the trial court at some point. Now, there may be issues with possible stays. If there's a money judgment against your client, they're probably not going to be able to post any bonds in order to keep it from being executed. But if there's an exception to that, if it's a cost-only judgment, then there is going to be a stay while the appeal is done. Even though you're not going to be paid for your representation in this case, you are going to want an engagement letter with the client that specifies the scope of the work. You're going to want to sign up to do an appeal, not to represent them in the Superior Court or in the California Supreme Court if review is granted. You're going to want to limit your representation to the Court of Appeal. Now, you may want to agree to file a petition for review in the California Supreme Court, but not to represent them under this agreement. You want to establish the authority that you have as an attorney, and that includes you are the person to charge of extensions, deciding whether extensions should be given or that you get extensions, and you also want to know if you can negotiate for the client with the other side, and you want that in the retainer agreement. You also want to know what they're going to do with what you can do with the papers after the case. In other words, after the case is over, how long do they have to pick up the papers? What are you going to do with them if they don't pick them up? And you want provisions in your retainer agreement about withdrawing from the case if there is a conflict or they just disappear on you. You want that in the retainer agreement. Your next step is to notify the program that you have accepted, that your client has accepted, and that you are now representing the client. You can do that by email. You'll want to sign up for the True Filing System. We used to have paper briefs that were filed. Those briefs are no longer filed in the Court of Appeal. You're going to be filing electronically, and you do that through the True Filing System at truefiling.com. You're going to want to sign up for that, and you're also going to want to get a credit card ready when you do that, because they're going to be charging you a $10.50 fee approximately to file every paper that you file. You're going to, at that point, you're going to do a substitution of attorney, so that you will, this court will know that you are now on the case, and that substitution and all other papers that they have will be served by electronically on your opposing counsel. You still have to file all your papers in hard copy with the Superior Court. Finally, you're going to be doing a civil case information statement, which is a statement that the court uses to determine if the appeal is timely or if you have an appealable order. You just fill that out. It's on a form which is provided to you by email, and also it's on the court website. You're going to need a couple of things to do that. One is a copy of the order or judgment which you're appealing from. They're going to want to see that. And also some information about your opposing counsel, such as their bar number and information about them, which you can get on the CalBar website. Finally, I think I ought to tell you that you need certain tools in order to file briefs in the Court of Appeal. You're going to need a computer, you're going to need a scanner, and you're going to need Adobe Acrobat Pro or a similar program which allows you to manipulate the documents in Adobe Acrobat so that they can be filed. Thank you for your attention, and now Kevin Green will be telling you about record designation and filing the briefs.
My name is Kevin Green, and I'm a certified appellate specialist. I'm going to speak with you today on designating the appellate record, briefing, and oral argument in the decisional process. Now, first of all, as to the record, you play a crucial role in ensuring that there is an adequate record for appeal. This is crucial for appellate review. In most cases, you will be representing the appellant. And this is an area where you can make a crucial difference, because litigants who haven't had counsel below commonly don't make a good record. In fact, it can be quite messy. And so this is an area that is crucially important to your work representing clients in this program. Now, the record on appeal consists of two components, the written record and the oral record. And everything I'm going to touch on today is covered in the California Rules of Court, starting at Rule 8.120 and down. So I'm just going to summarize and touch on some of the key aspects of what those rules say. For the written record, these are the documents filed in Superior Court that are relevant to the appeal. This is under Rule 8.122, and you will most likely designate a clerk's transcript because it is free for fee waiver litigants in Superior Court. And the clerk's transcript simply includes all documents that are relevant to the issues on appeal, including trial exhibits. Now, an alternative to the clerk's transcript is an appendix under Rule 8.124, and many lawyers prefer this. Many practitioners prefer it, and it's akin to the Ninth Circuit excerpts of record, but most likely you will not be doing it unless you want to bear the cost on behalf of the client. Now, moving on to the oral record on appeal, most familiar to you will be a reporter's transcript of any hearing that is relevant to the appeal. This is under Rule 8.130, And this is also crucial to ensuring an adequate record for appellate review. If there was a hearing, it's vital to find out if there was a court reporter present and to obtain a copy of the transcript for appeal, because there's ample California case law dismissing appeals for lack of a reporter's transcript, even if the transcript isn't relevant. The appellate court needs to review it just to see what the trial court said. Now, if there was no court reporter at the hearing, an alternative way to obtain a copy of the oral proceedings or assemble some record for the appellate court is the agreed or settled statement. And these were not commonly used some years ago, but have become more common lately because of court reporters going by the wayside. And the agreed or settled statement, typically it's a settled statement, is under rules 8.134 and 8.137. And I'm not going to go into detail as to that procedure, but if there was no reporter at the hearing, this is something to consider and is worth doing to avoid forfeiture of issues on appeal. Moving on to the briefing stage of the appeal. This part will be most familiar to you from briefs that you've done, say more commonly in trial courts. I'm just going to touch on 2 points. First, on scheduling, there's a provision that is pretty unique in the California rules, 8.212, governing stipulations to extend the briefing schedule. And this is a provision that allows you to extend the schedule up to 60 days on each brief without leave of court. It's effective on filing, so you don't need to make a motion. And it is good practice to contact the other side, especially if there is counsel, and try to stipulate. The rules encourage it, the court prefers it and appreciates it, and it's a very easy way to extend your schedule if you need to do that. Secondly, and related to that, the timing of briefing is a matter that should be within your professional discretion, not something controlled by the client, and that's something to have in the retainer agreement. And as to the substance of briefing, especially with self-represented parties in the trial court, you may have waiver or forfeiture issues. And the details of those are beyond the scope of what I'm going to be able to talk about today, but it's just something to look at and be aware of if an argument wasn't made below or not sufficiently developed and preserved for appeal. Moving on to oral argument, each side gets 15 minutes, and the oral argument in the Court of Appeal is a little different from some other courts in that the court typically has a draft opinion at the time of argument, and that's due to what's known commonly as the 90-day rule, that the court is required to issue its opinion within 90 days of submission, which is typically the day of argument. And so the process is somewhat front-loaded and emphasizes the briefs a little bit more than other courts and federal practice. So oral argument is quite often focused a little bit more on nuances of an appeal and not necessarily flipping the court, which is usually difficult to do, but especially so in the Court of Appeal. Now, the Court of Appeal should send you a form to request oral argument. There's a state constitutional right to it, but you do have to request it. You have to return the form requesting oral argument, and that should be sent to you as counsel of record. Now, last to close, this has been a primer on the appellate process, and it's not intended to be great detail. The program has a wonderful set of mentors that you can reach out to and contact. You should not hesitate for general questions about appellate practice. And these are people who have done appellate law for a long time, decades of experience, to reach out to, and even specific questions about your case, if you have any, that you're comfortable running by a mentor and want to discuss. And last, thank you very much for participating in this vital program in attempting to enhance and improve access to justice on appeal. It's something that we're very proud to do, and we're very pleased that you're part of it. So thank you.